With a literal hurricane hitting Florida, I thought we might have a lack of documents to cover in the Sarah Boone case, but no, we have extremely important ones and quite a few to go over. This is the state's preliminary objections to defendant's amended exhibit list. So they're going after her exhibits in this one. And don't worry, later they're going to be going after even more. Comes now the state of Florida by and through the undersigned assistant state attorney, states and alleges as follows. On September 26, 2024 at 7:21 p.m., the state received an amended exhibit list from the defendant. This is outside the scope of the timeline the defendant was allowed to list exhibits, but the court granted leeway for a potential extension. The potential admissibility of battered spouse evidence has changed the feasibility of all of the court's deadlines in its scheduling order from August 5th, 2024. Items 1 through 3, which the defendant does not even have yet, will likely require hearsay relevance and 90.403 objections to be made, resulting in either their exclusion or voluminous redactions to be made. Also, these records may require the battered spouse syndrome experts to have re-examined the defendant and potentially be redeposed. So right here, she doesn't even have these items. There's going to be tons of objections, and they're now talking about needing to have the experts meet with her again. The trial's supposed to start on the 7th of October. This is feeling we might get a delay. Items 4 through 7 are police reports. Police reports are inadmissible hearsay in Florida. Which is interesting because shouldn't the lawyer of hers know this? It is unclear whether the defendant believes she can use these reports in her case in chief or for potential rebuttal. The latter may provide some limited admissibility. Reliance on inadmissible evidence by experts is permissible, but it does not make the inadmissible evidence admissible. Regarding items 8 through 11, the state notifies the defendant that it will potentially use photographs of George Torres's injuries as well. This will also involve the testimony of deputies who observed George Torres's injuries during these prior incidents. Item 12 includes inadmissible hearsay from the defendant. I don't know where to find this list if it's public, by the way, I looked. Item 13 is inadmissible character evidence, Florida Statute 90.404. If the defendant does testify that she used justifiable deadly force against George Torres in the evening she killed him, she is permitted to testify to prior acts of violence committed by George Torres that she was aware of. This, however, does not allow a rap sheet to be admitted into evidence. Item 14 is another police report, which is inadmissible, as explained above. Item 15 is inadmissible character evidence. The attacks on the decedent's character in self-defense case are limited to reputation for violence, evidence of specific acts of violence, which the defendant committed that the defendant was aware of. Item 16 is irrelevant and likely filled with hearsay. The state has not been provided this information. Items 17 and 18 are irrelevant and inadmissible. Item 19, A through O, are inadmissible hearsay, and the 911 calls the undersigned has heard from June 18, 2019 to September 4, 2019. The defendant makes it clear to the dispatch that it is not an emergency and that these statements are not excited utterances. They are merely inadmissible, self-serving hearsay. The remainder of the calls were not potentially relevant to this case until the defendant alleged the relevance of battered spouse evidence and has not been reviewed by the state. So the state has not even reviewed these yet. Again, I'm thinking delay coming. Item 20 does not appear to be relevant other than showing that the defendant had no injuries. 15 is, unless otherwise noted below, the state does not have any preliminary objections at this time to item 21 through 51 without waiving any potential objections as the trial develops, and not waiving the predicate for a photograph movie being required prior to these items being admitted into evidence. Items 25 through 28 are irrelevant. Items 23, 34, 35, 38 are duplicative. Item 41 is irrelevant. Item 33 and 43 are duplicative. Item 48 contains inadmissible hearsay. Item 51 contains inadmissible hearsay. So that's pretty wild right there. They're going hard into that exhibit list, but we have more to cover. There's so much. So here we have the state's objection to the defendant's second amended reciprocal discovery exhibit list. Comes now to the state of Florida, by and through the undersigned assistant state attorney. The state alleges as follows. The state received the second amended exhibit list at 10:44 p.m. on September 26, 2024. The only apparent change was adding item 13, jail phone calls involving the defendant and third parties when received. While the state may introduce statements of the defendant as a party opponent, the state is struggling to see any hearsay exceptions that would allow the defendant to introduce any jail phone calls. So they had another amended exhibit. They tried to introduce phone calls, and I wonder why. Maybe she admitted on one of the calls she did it on purpose, and that's why they're wanting to put it in there. Just interesting to me. Okay, so here we have the state's response to the defendant's objections to plaintiff's exhibit list. Whew. Comes now the state of Florida, by and through the undersigned assistant state attorney, and states and alleges as follows. On April 13, 2020, the court entered a uniform order setting pretrial conference and trial. Part 1, 5B, don't make fun of me if I got my Roman numerals wrong, requires the party to file all pretrial motions 10 days prior to the pretrial conference and cautions that late filings of motions may result in denial without hearing. The defendant has had copies of the statement she made to law enforcement for over 4 years. Now at 11:43 p.m. So this is what's so crazy. This is happening like at the last second. On September 26, 2024, during the hurricane, just pointing that out, the evening after which her pretrial conference was scheduled, filed an legally insufficient motion to suppress her statements made to Deputy Kayla Rodriguez, the first two statements made to Detectives Copesel and Lauren. So she's trying to go against the deputy as well. I think this, it must be she's going after, Deputy Rodriguez. Is she the one that was at the scene, I think? Florida Rule of Criminal Procedure. This comes on the heels of another delinquent and legally insufficient motion to suppress statements filed on September 24, 2026, 2 days prior to the pretrial conference. It is unclear why these statements were not made a part of the motion to suppress filed on September 24, 2024. Yeah, that's the thing, right? September 2024, that is the day, if I'm remembering right, they filed the big motion to suppress. We're going to go to the state's response soon. The big motion to suppress all of her interview. Why did they do this now? The court should require the defendant to file a proper motion to suppress so the state can enjoy a pretrial ruling on the motion and the jury does not have its time needlessly wasted. Oh boy. This is the defendant's motion for right to hair, cosmetics, and civilian clothing without restraints for trial. So, we saw that the state is completely and utterly destroying, or at least trying to destroy, their attempts at all this evidence and exhibits. They're going after them hard. And then we have this. We have what appears to be, at least to me, a very, very well thought out document about hair, cosmetics, and civilian clothing. I wouldn't be putting my effort into this personally. I would be trying to do more ironclad stuff with my exhibits. Comes now the defendant, by and through the undersigned counsel, moves this honorable court for an order permitting defendant to appear in all court proceedings pertaining to trial in civilian clothes without restraint instead of jail uniform. In addition, the defendant requests that she be permitted the right to have her hair styled and access to makeup. In support, therefore, the defendant states the following. The defendant is presently incarcerated and scheduled for trial on October 7, 2024. I keep thinking we're going to get a delay. Defendant has been incarcerated for over 4 years, and defense will get access to professional hairstyling, cosmetics, civilian clothing without restraints throughout the defendant's trial appearance in respect to the court and prospective jurors. Without the court entering an order permitting her access to such, the right to receive a fair trial will be impermissibly infringed upon. Now, does she really need professional hairstyling? I feel like she could make her hair okay for trial, right? Cosmetics, like makeup and stuff, I could possibly see that, right? And civilian clothing, sure. Without restraints, maybe with shock cuffs. But does she really need like the state to pay for a professional hairstyler for her? I don't know if they'll approve that one. That just seems a little much to me, but maybe it's not. And here we have the right to civilian clothes. I'm not going to read the legal argument at the top, but here the defendant is scheduled for trial on October 7th, 2024. The defendant will be transferred from Orange County Jail daily for trial proceedings. Defense counsel will provide the defendant with professional attire for the court appearance. In addition, the defense will need to obtain defendant's measurements. Therefore, defendant requests the court to enter an order placing the Orange County Jail on notice that 1, the defendant is permitted to take defendant's measurements, and 2, the defendant is permitted to dress out in her civilian clothes for trial proceedings. Right to appear without physical restraints. On September 19, 2024, the defendant appeared in court bearing handcuffs and shackles. Defendant's hands restraints made it difficult for her to communicate with counsel in written note-taking form. In addition, it is reasonable to assume the next court hearing will be covered by local national media. If defendant is put on display to prospective jurors and jail guard, they will naturally be led to doubt her presumption of innocence. Therefore, defendant is requesting that the hand restraints be removed at all court proceedings from here on out, and that both shackles and handcuffs be removed during trial proceedings. And here we have right to control appearance in the courtroom before the jury, and allowing the defendant to present herself in a manner that does not unduly prejudice the jury is essential to ensuring her right to a fair trial, upholding the presumption of innocence. And while the court in Estill specifically addressed partisan attire, the underlying principle applies broadly to any aspect of a defendant's appearance that could influence the jury's perception. Defendant has a right to appear before this court and protect the jurors in the same manner as she would outside confinement. Cosmetics and hairstyling is standard practice in presenting a professional appearance if the individual chooses. By extension, incarcerated males are permitted a fresh shave and a haircut. Accordingly, the defendant requests you be permitted access to cosmetics and hairstyling throughout her trial proceedings, including void dyer. I'm going to be honest, I don't remember what that word means, what that combo means. But let's move on to the next thing. This is just, she's showing that they put some effort in here. State's motion to strike defendant's motion to suppress statements at OCSO and state's response to defendant's motion to suppress statements at OCSO. So, what a title. I just want to say that. What a title. Comes now the state of Florida by and through the undersigned assistant state attorney, states alleged as follows. The defendant's motion is legally insufficient. The defendant recites allegations of facts, but not why any particular fact or facts is an issue. The reasons for suppression, as required by Florida Rule of Criminal Procedure 3.190H2, is a boilerplate assertion that it violated the United States Constitution and the Florida Constitution. This is no different than stating a search was performed illegally, improperly, and unlawfully. Motion to suppress cited 11 authoritative cases was legally sufficient. The defendant has not cited even a single case that authorizes the court to grant her the relief she is requesting. The state is left in the dark about what specific issues the defendant is claiming and what legal authority there might be for the court to grant the relief she requests. The court should strike the motion as legally insufficient. The state objects to any additional claims being raised at the hearing that were not specifically pled in the defense's motion. In paragraphs 5 and 6 of her motion, she alleged she was detained for 14 hours, and during this time she provided a statement to law enforcement. She does not challenge the admissibility of this statement. And here we have Chavez v. State. 54 hours of detention does not make a statement involuntary. So that sounds like they got something against her right there. She says 14, they have 54 is okay. Paragraphs 7 and 8 of the defendant's motion allege that law enforcement asked for the defendant to turn over her phone and that she provided the means to unlock it to law enforcement. Bell v. State is informative on this issue if it is the defendant's position that has somehow rendered her statement the following day involuntary. Bell makes it clear that the police having seized evidence from a suspect and the suspect knowing they have seized evidence from her only goes towards the analysis about as whether a future interrogation is custodial, not whether a future statement is involuntary. Because Miranda warnings were provided at the beginning of the interview the following day, this is not a relevant factor for the court to consider. Bell is also informative on the distinction between a Miranda violation and an involuntary statement, which will be discussed below. Paragraphs 9 through 11 of the defendant's motion imply that law enforcement was being deceptive in their manner of summoning her for an interview. She did not know what's going to occur. Pursuant to Bell, this is one of the Ramirez factors in deciding whether Miranda warnings were required, not whether a statement is involuntary. Now, I've already covered, by the way, what they're responding to here in a previous video if you missed it. This is different from the deception that would lead to an involuntary statement. The defendant received no promises of hope, leniency, or misrepresentations about the law. Both the United States Supreme Court and the Florida Supreme Court have held that deception alone does not negate voluntariness. This includes misrepresenting a co-defendant's statement, false suggestions that law enforcement could arrange a satellite system to put a defendant at the scene, exaggerating the amount of DNA evidence against a suspect, informing a suspect that law enforcement was investigating a missing person case rather than a homicide, writing DNA evidence on a whiteboard in an interview room prior to any DNA analysis being performed, and false representations of physical evidence that did not exist. The police can lie to you. Maybe Sarah Boone didn't know that. Like there's a chance, but that's her fault. Like they can lie to you. We know that. Whether you agree with it or not, like they can. That's why they went so in depth there. Basically, like, look, all of this is okay, so obviously them lying to her is okay. Luring the defendant to the sheriff's office under the guise of returning her phone to her, if that is in fact what happened, they're not even saying that's what happened, does not make the statement involuntary. It only goes towards whether Miranda should have been read, and it was. Paragraphs 12 and 13 only go towards the first Ramirez factor as to whether Miranda should have been read to the defendant. She was led upstairs to one of the interview rooms in the sheriff's office by Deputy Loren, where an interrogation ensued after Miranda was read to the defendant. Nor is there coercion, so the defendant has not specifically made that claim or cited authority. Martin v. State, allegations that law enforcement threatened the suspect with a death penalty, deluded the suspect as to what he could expect for himself and the jury if he confessed, deceived the defendant as to the amount of time he could cooperate with law enforcement. 4. Promised their favorable testimony and used their influence during his trial if he cooperated. 5. Promised to arrange a visit for him with his girlfriend if he cooperates. 6. Exploited his religious beliefs by relying on a version of the Christian burial interrogation technique. Did not render the statement involuntary, though it presented the very outer limit as to what tactics law enforcement may employ when performing a custodial interrogation. So again, they're defending all of this is okay. Obviously, them sitting down with her for this interrogation is okay. Although the defendant never states that part of the reason she believes her statement should be suppressed was the minimization of her Miranda warnings, nor cites any case law on the subject, the state infers that she believes this is an issue due to what she has underlined in paragraph 15 of her motion. There are several cases addressing the issue of minimizing the importance of Miranda warnings, Ross v. State, and so on, saying this is something I have to do is not minimizing according to Wright, which is analogous to Detective Copesville saying, so I'm going to read you your rights again because we have to talk about that. We just have to do it. They were read in a normal cadence, like in Chaffin. There was no delay in reading them. The defendant is not a juvenile. Now, come on. Mentally, and there is no claim that she is of below average intelligence. She has been read her Miranda warnings just a day before and acknowledged this. It is the defendant who says it is normal protocol. These statements by law enforcement did not render her waiver of Miranda rights involuntary or her statement involuntary under a totality of circumstances analysis. In the balance of paragraph 15 of her motion, the defendant outlines the Miranda warnings as they were given to her by Detective Copesville. Paragraphs 17 through 21 outline that she believes the sheriff's office Miranda card says and how it differs from what she was told by Detective Copesville. Interestingly, the defendant believes that this creates some sort of legal impediment to the admissibility of her 2-hour statement that today is not backed up by a single citation to any legal authority within or without the state of Florida's court system. Instead, she makes a boilerplate assertion in paragraph 22 that her statement was involuntary and her waiver of her Miranda rights was involuntary. Fortunately for the state of Florida, there is case law on this issue. There is no specific way that Miranda warnings must be given, and with all due respect to the Orange County Sheriff's Office, they certainly do not have the authority to tell this court what sufficient Miranda warnings are. Ooh. Basically, the court doesn't get to decide. While the 4 required warnings have become embedded in police practice, the specific words used vary, and the Supreme Court has not dictated the words in which the essential information must be conveyed. Morris v. State, there is no talismanic incantation required to ensure that Miranda warnings are sufficiently conveyed. Rather, the inquiry is simply whether the warnings reasonably convey to a suspect his rights are as required by Miranda. The crucial test for determining whether police had a proper warning is whether the words in the context used, considering the age, background, and intelligence of the individual being interrogated, are a clear, understandable warning of all of his rights. Detective Copesville specifically instructed the defendant on each of her 4 Miranda rights. 1. Right to remain silent. 2. Anything said can be used against her. 3. Had a right to an attorney before and during questioning. 4. A lawyer could be appointed if she could not afford one. The detective then asked the defendant if she understood these rights, and the defendant said she did. State v. Owens is directly on point. There, the defendant was read the four Miranda rights, asked if he understood them, and asked if anyone had threatened him or promised him anything. There was no mention of any question about whether the defendant wanted to talk to law enforcement after he was given the Miranda warnings. This is apparently the Federal Bureau of Investigation's Miranda warnings, which were described as exemplary. So, they're literally saying, look, the FBI says basically the same thing as the detective did to her, and it was considered exemplary. So there's no case, no argument here. That's what they're going with. The Miranda decision never contemplated that waiver of counsel could be accomplished only by the use of words. I am willing to answer questions without the service of a lawyer. There is no magic in these words. Any clear and ambiguous conduct by a person who has been advised by his rights, which indicates his willingness to answer questions without a lawyer, is surely sufficient. Therefore, if the court does not strike the defendant's motion to suppress for being legally insufficient, it should deny it on its merits. If the court believes there was a Miranda violation, the defendant's statements are still available for use during cross-examination. Only if the courts find the statements to be involuntary will the state be prohibited from using them in a cross-examination. That's long, about as long as the title, but essentially what they're saying is there's no basis. Their argument is there's no basis at all for her lawyer's motion to suppress. None. It's not going to work, and even if the judge somehow sides with them, it's still going to be used against her in cross-examination. So, and there's more. So, all of this is going to go to a hearing. Defendant's motion to suppress defendant's statement at OCO, defendant's motion for a right to hair, cosmetics, civilian clothing. All of this is going to be in court October 2nd. It's just 5 days before the scheduled trial. And again, I have to wonder, are we going to get a delay? I can feel it, right? Because, like, as they mentioned in a previous document we covered, some of this stuff, if it's allowed, if the judge allows the evidence, allows the exhibit, it could mean they have to do more interviews and things with her and with the person doing the interview and all of this, and it's just going to possibly delay things. And remember, we're also dealing with a hurricane. And will all the witnesses be able to show up now? If there's an exhibit or something going on and they need to have this person meet with Sarah Boone, do they live in an area affected by the hurricane? Can they make it? Or are they, natural disaster keeping them busy? Is their home damaged? Do they have to be there to recover? Like, the hurricane could end up being involved because the defense is still grabbing different people out. And if they want a delay, if they're trying for a delay, I would not be shocked if they try to add someone in who's directly in the path, in some way tangentially is connected to Sarah Boone. Now, from my understanding, maybe I'm misremembering, I think where they lived was maybe hit with storm surge or like that general area. It's hard. I'm thinking she was in the Tampa area, but I could be misremembering. This is one of the first things I've recorded today. I've just gotten up recently. You probably noticed me chugging an energy drink. But yeah, I wanted to make the video because to me, I was like, this is what I thought. I thought I was going to sit down. There's going to be no updates because of the storm, and I'm going to get to do other stuff. I'm going to get to cover other content. And instead, I was just full of documents. There's more documents than what I covered, and I'm going to end it here. Now there might be, I might edit in somewhere in the middle of this if I can find this list of exhibits. But as far as I could find, because I scrolled through, maybe I missed them. I didn't see them listed in the actual documents.